is with us today in the team. She's from the Malaysian bar. Thank you.
On a balance of probabilities and based on the evidence presented before the panel, there was no direct or circumstantial evidence to support the contention that Joshua Hilmy and Ruth Sitepu were abducted by an agent of the state. However, it was the panel's finding that the highly unsatisfactory conduct and shortcomings of the Royal Malaysian Police in investigating the disappearance of Joshua Hilmy and Ruth Sitepu had contributed to the acquiescence of the state in the abduction of the couple, which can be summarized as follows. The panel believes that it is the responsibility of the investigating officer to use all available means to gather information about the missing couple, and it is essential to do it at the preliminary stage of the investigation on an urgent basis. The panel is of the view that the delay and extremely slow response time in taking this action reflects poorly on the police. It shows that the police was not taking proactive measures in investigating the case. It was also found that there were several potential witnesses who could have assisted police investigation. For instance, the children of W1, namely IW2 and IW3, who were staying at Joshua Hilmy's house in Kampung Tunggu. However, their statements were not recorded by Ahmad CB at the early stage of the investigation. Lack of thorough assessment of the witnesses had impacted adversely on the next course of action of the investigation. Sergeant Ahmad CB, as the first investigating officer, was incompetent and not serious in conducting investigation at the preliminary stage. The case should have been assigned to a senior officer, that is to say, at least the rank of inspector, who could be more competent in conducting investigation. Based on the evidence presented before the panel, Joshua Hilmy is known as a pastor, and he had conducted baptism rituals at his house. In this regard, the panel found that none of the investigating officers testified had attempted to investigate Joshua Hilmy's Facebook account. The panel is of the view that this is rather strange, as the police should have investigated Joshua Hilmy's Facebook postings to find any lead that might be useful for the purpose of the case. The panel is of the view that the Royal Malaysia Police has failed to investigate the disappearances of Joshua Hilmy and Ruth Sitepu in the manner as it ought to be, diligently and seriously. Even though there was some pertinent information found during the early stage of the investigations, it was not taken seriously by the police, and no danger alert was triggered. The panel is of the view that the lack of interest and seriousness on the part of the police in appreciating the severity of the case, and instead merely treating it as normal missing person case, reflects the failure of the police to prioritize the case. Next issue, main issue for us to make a determination whether there is a refusal to acknowledge the deprivation of liberty, or whether there is concealment of the fate or whereabouts of the disputed person, which place such a person outside the protection of the law. It is the finding of the panel from the evidence adduced before it, in particular the evidence relating to sloppy and tardy police investigation. There is a refusal on the part of the Royal Malaysia Police to acknowledge the deprivation of liberty of Joshua Hilmy and Ruth Sitepu, and such Refusal to acknowledge has placed them outside the protection of the law. This is the finding of this panel, that so far as the present case is concerned, the state has given zero information about the disappearances and or the progress of the case of Joshua Hilmy and Ruth Sitepu. The Royal Malaysia Police has a duty to protect the citizens of this country from harm, and other nationals as well, as long as they are on Malaysian soil. The Royal Malaysia Police is expected to safeguard human rights. Pursuant to the panel's last item of term of reference, namely to recommend measures or guidelines to be taken to ensure that such alleged breach of breaches do not recur, the panel makes the following recommendation. Number 1, strengthen and improvise the standard operating procedures of the police relating to the investigations of missing persons, abduction, and disappearances. Number 2, to step up investigations on the disappearances of Joshua Hilmy and Ruth Sitepu. As the police investigations on the disappearances of Joshua Hilmy and Ruth Sitepu are still ongoing, it is our recommendation that the Royal Malaysia Police must earnestly and seriously step up its investigation on the case, taking into account the criticisms and the recommendations that we make in this report. Number 3, police investigation paper to be shared with other bodies with investigative powers. Throughout the public inquiry, the Royal Malaysia Police was reluctant to share the investigation diary or any other documents in the IP because it is claimed that the IP is classified as confidential under the provisions of the OSA. The panel takes the position that such a view undermines the purpose and efficacy of Section 14 of the Suhakam Act. Certain important documents in the IP should be shared in the public inquiry as evidence to facilitate the panel's investigation in the interest of justice and public interest. Number 4, enhance forensic investigation. The panel observed that the police investigating officers lack investigating skills in carrying out their investigations. The investigating officers fail to examine crucial evidence and to look for new leads in the case. Number 5, promote and provide education on witness protection program in Malaysia. The panel observed that there are some witnesses who were reluctant to provide information or to testify in relation to the disappearances of Joshua Hilmy and Ruth Sitepu, or after having noticed that both Joshua Hilmy and Ruth Sitepu had gone missing, were hesitant to report the matter to the police. This is due to the nature of the case, where the Royal Malaysia Police were perceived as the, quote, suspect behind the couple's disappearances. Such perception was exacerbated by the widely publicized disappearances of Amri Chekmat and Pastor Raymond Koh. We believe this is due to the lack of public awareness of the Witness Protection Program in Malaysia, which is governed by the Witness Protection Act of 2009. It is the panel's view that it is the duty of the ministry responsible for the program to promote and educate the public on the Witness Protection Program in Malaysia, so as to instill more confidence in the public in order to encourage persons with information and potential witnesses to come forward and to provide information and evidence. Number 6, authorities to respect freedom of religion as fundamental human rights. Number 7, legal reform on existing legislation. The panel recommends that the government should review the penal code to incorporate the offence of enforced or involuntary disappearance as a separate category specific to cases involving missing persons. In other words, the amendments should effectively make it an offence under the penal code, in addition to and separate from the offence of abduction and kidnapping. Number 8, law on hate speech in Malaysia. It must be noted that both the Federal Constitution, UDHR and ICCPR establish a high threshold for restricting speech and further imply the need to criminalize speech only when less extreme measures are insufficient. Taking into consideration from the above, the panel recommends that the government do enact legislation to combat hate speech in Malaysia in place of the Sedition Act of 1948. Such a law is necessary to prevent any person, including those from the government institutions and enforcement agencies, from making inflammatory public speeches and to incite or promote hatred. Number 9, accession to International Convention for the Protection of All Persons from Enforced Disappearance 2006. Malaysia has not acceded to the International Convention for the Protection of All Persons from Enforced Disappearance 2006 ICPPED. Therefore, Malaysia is not a party to the said international convention. We recommend that Malaysia accedes to the ICCPED. By acceding to the convention, Malaysia will assume an international obligation to eradicate enforced disappearances. Number 10, and that is our last recommendation, Independent Police Complaints and Misconduct Commission, IPCMC. The panel recommends that an independent police complaint and misconduct commission should be established as recommended by the Royal Commission of Inquiry appointed by the government in 2004 and chaired by former Chief Justice Tun Muhammad Zaidin instead of the intended IPCC. In addition, the panel calls upon the Royal Malaysian Police to take heed of the royal recommendation of the RCI in the report, namely that the Royal Malaysian Police A. adopts and adheres to a strong code of ethics, B. be transparent and accountable to the public, C. be subject to a credible external oversight mechanism in the form of the proposed IPCMC, D. be more representative of the various groups in the country, E. to be more responsive to the requirements of the community through programs such as community policing, and finally F. should be an organization that is infused with human rights values and discharges the responsibilities towards maintaining law and order in a human rights compliant way. It is submitted that by establishing the IPCMC and adopting the recommendations of the RCI report holistically, there will be a proper check and balance on the police.